My name is Stephen Scarlett. I retired just over a month ago as a judge of the Federal Circuit Court. I was one of the original federal magistrates appointed in 2000, so from day one and through until the 28th of July I was a federal magistrate and then a judge. What I want to talk to you about this morning are delay, resources, funding. We in the courts, or my former colleagues in the courts, are very concerned about delays in courts. My view, and I'd stress that these are my views, they're not necessarily the views of the court as a whole, or the Chief Judge in particular. My view is that delays are largely contributed to by the lack of resourcing of the court, and the lack of resourcing is pretty much a direct result of the lack of funding. Now, when you look at court delays, I did, before I came here, make some inquiries of my former colleagues in other registries in New South Wales and the ACT, just to find out how far out everyone is listed. If we were setting down a matter for final hearing today, when can we expect it to get on? The answer unanimously was, well, you can forget about 2017, it's full. That they are listing well into 2018, and indeed, if a matter has its first return date at this stage, it'll be late in 2018 before a final hearing can be allocated. This is really a source of concern because the longer matters remain in the system, the more chance there is for things to go wrong and require interim applications, and the final hearing then gets pushed further and further out. What causes it? It's not because the judges aren't working hard enough, because believe me, they are. It's caused by a lack of resourcing. One of the most obvious ones is the lack of judicial resources, and to that extent it's not a matter of funding. The government has been tardy, and historically tardy, in replacing judges as they retire. A judge retired from the Sydney Registry at the end of January last year. It took 13 months for her replacement to come on board. Now, what that means, when you have a gap like that, it doesn't mean that the work stops coming in. It still comes in. It just takes longer for the existing judges to get to it. And my experience has been that you never catch that time up. Once the delay is built in due to the failure to replace a judge promptly, that delay stays. Now, 3 judges have retired from the court this year in Launceston, Canberra and here in Sydney. They retired in early June, middle of July, and in my case, the end of July. As of last night, I was aware that there was just no word as to when any of those 3 positions are going to be filled. And yet all of these positions are funded. There is money set aside to pay for judges and the necessary associate support, but it's not being spent. The funding is such that my replacement could be tapped on the shoulder this afternoon and he or she could turn up at the court on Monday morning and would be paid, would be provided with a phone, would be provided with a computer, because the money's there but it is not being spent. Now, you cannot say that the Attorney General's Department has not had notice of these retirements. All three of us who retired this year have retired because we reached the statutory retiring age. Mr. President, you heard my complaints about the ridiculously low statutory retiring age only about a month ago. But the fact is, the government knew when I was appointed, when I was going to go. They knew when I had to go. They had 16 years' notice. I don't know who my replacement is going to be or when he or she is going to turn up. And that creates serious difficulties for the courts. And where you have judges moving towards retirement, what then happens is that they have to run down their dockets. They can't keep taking fresh matters in, and that means that that judge closes his or her docket, and that means that the flood of work then has to go to the other judges with, again, a consequent build-up of delay. But the court is short of resources. The court could do with more judges. There is no statutory cap on the number of judges. You could go through the Federal Circuit Court of Australia Act 1999 and there's no section that says the number of judges is set at 65. The government could appoint 100 judges if it had the will and the money. They could appoint more judges. But what does happen is that getting people to take appointments is not that quick. You'd like to think that there'd be dozens of people out there in the profession, solicitors and barristers, who would make good judges, yes, and many of them would be happy to take an appointment. But many of the ones who are really successful in the profession are most reluctant to go to a court where the judges don't have access to the judicial pension. Yes, the Federal Circuit Court is the only federal court where the judges are not entitled to the judicial pension. I can't complain about the judicial pension, there isn't one. And for many at the bar, for many earning a good living as solicitors, the absence of a pension is a serious factor that would incline them not to take an appointment. And if there's one thing the court needs, whether it's in the General Federal Law Division or the Family Law Division, it is good, capable practitioners who will be good, capable judges. My belief is that the lack of resources hits the court in other ways. For instance, it would help if the court had more registrar support. If more registrar support was available, registrars with appropriate delegations could do a lot of the things that judges are doing now. The original model for the Federal Magistrates Court, when it first started sitting on the 3rd of July 2000, is probably no longer appropriate because the court has grown, its jurisdiction has grown, it's had a vast amount of work come in that was never contemplated. Just look at the court's migration jurisdiction. It was never thought in 2000 or in 1999 that the court was going to be the primary court for migration applications. But look now, it is the trial court for migration, and there is a flood of that work. But registrars could do a lot of list work. Registrars with appropriate delegations could even do interim hearings, and they could certainly free the judges from the more administrative things the judges doing lists are still required to do. And this was made very clear to me by a barrister who spoke to me and volunteered that information only very recently. And he was right. More registrar resources would enable more conciliation conferences to take place. The settlement rate in Sydney for conciliation conferences is not as high as it should be because there's so much of a pressure on registrars to get the conferences on that they squeeze them in. I think 3 conciliation conferences in a day is pushing it. It is too much. There should be a maximum of 2, because so often if a matter gets close to settlement and they run out of time, often the momentum is lost. And if your final hearing date's going to be 18 months or 2 years away, it is good value to resolve matters, particularly property matters, early on rather than late. More resourcing would also give more family reports, more family consultant availability. It used to be the case that a lot of people would take their parenting matters to family consultants when it looked as if the matters would never resolve, and they'd come out of the Child Dispute Conference having pretty well achieved a resolution which their employers could then write up. It tends not to happen these days, again because of the restriction on the number of resources. And I think the lack of resources, and this is probably the last point I'll make, affects the court in other ways. The huge cuts to legal aid, particularly in family law, have meant that fewer and fewer people are legally represented. Often people have a grant of legal aid, but the case happens that their grant's withdrawn. They go ahead anyway, so you're getting a greater number of unrepresented litigants. And self-represented litigants take longer to hear. More money to the court, more money to the legal aid commissions right across Australia would go a really long way towards getting people's cases into the court, on before a judge and out of the court. They're my views on funding and resources, and I'm happy to take questions.
Thank you, Judge. Could I ask you if you could give us a sense of the caseload of the judges of the Federal Circuit Court? They operate under a docket system.
They do.
In terms of numbers of matters that each judge would handle each year, perhaps you can give us an idea of that.
It varies according to the registry. The docket numbers are lower in Sydney, but you're easily looking at 350, 370, 400. You can have more. In Wollongong, I know it's considerably more. And just managing a docket of that size involves a lot of administrative work.
Is technology part of the solution in terms of processing work and getting through it more efficiently?
It's part of the solution with things like electronic filing, which the court is doing both in its general federal law jurisdiction and its family law jurisdiction. That's one way of getting the matters in. Technology in the form of telephone conferences, video links, etc. is pretty important, especially as the court has an obligation to, as its name implies, go on circuit. So you're often dealing with litigants a long way away. In many cases, it's difficult for us to go all the way to Coffs Harbour or Dubbo or wherever, and a lot of matters can be done electronically. That is one of the ways, yes.
Is resourcing an impediment to judges being permanently based in country regions?
Oh, without a doubt. I mean, you only have to look at, say, the local court, where they do have resident magistrates in places like Wagga and Orange and Bathurst. We don't have the resources at the moment to place judges in an area. I think a very obvious example would be the Coffs Harbour Lismore area. If you had a judge there, he or she could deal with that whole northern New South Wales area without having to fly up from Sydney or down from Brisbane.
Judge, you spoke about the increase in unrepresented litigants.
Yes.
And the last 2 hearings we've had have been a number of academics and deans from law schools, and we explored with them the number of students that were going through law school at the moment and not achieving employment at the end of their studies. So my question to you, if I may, is do you think there's any scope for non-lawyers to assist the court in any way, in particular students who may not have a job to go to? Or alternatively, would it be helpful for them to do perhaps some practical legal training in a courtroom?
I think that would be a very good idea for a number of reasons. It would assist the court if there were just more people employed in the court system to do a lot of the administrative stuff. I mean, I don't think someone in third year law should start hearing cases for obvious reasons, but there's a whole lot of work that can be done. And there are, at the registry in Sydney, there are a lot of people who are third or fourth year law students who are actually working in relatively low paid positions like in records. I did comment that one young lady who came up and delivered some files, I said, geez, remarkably well dressed for someone in records. And my associate said, oh, she's going through the College of Law. And in fact, the lady concerned became deputy associate for me only about a year or so later.
Oh, terrific.
So there are a lot of people working there. And the other thing, though, is that it's of benefit for people who want to make their life in the profession to actually be in a court and see how it works, to look at the forum, see who the good lawyers are, see who the bad lawyers are. I have work experience, or I had work experience students, and I try to get them to think like a lawyer. What did you think? What did you think of the way that case was presented? How well did you think Mr. So-and-so did? Did you see what was happening with the witnesses? To make them think like lawyers and just get a practical nuts and bolts idea of how courts work. Yeah, I would encourage it.
And may I ask you another question? You made reference to judges who have retired like yourself not being replaced, and I wondered if I could ask you why. Why are they not being replaced? If the funding's there, why is the Attorney General's office not replacing them? Why is the government not replacing them?
Saves money?
So that's it?
I suppose.
Right.
I mean, if the funding's available...
Why is it not being spent?
Why isn't the President of the Law Society attending a ceremonial sitting for my replacement tomorrow morning? The system could afford can afford 3 more judges right now. Why? I think that's the question for the Attorney General. When are the new appointments coming? Because they are they're needed yesterday.
Certainly. Gary?
Can I just go back to the situation with unrepresented litigants? I think you said that dealing with unrepresented litigants often means that a hearing will be extended. It takes
Yes.
a lot longer.
Yes.
What is the situation where you have both parties being unrepresented, and does that happen often?
Yes. It is happening more and more frequently, and in fact anecdotal evidence I've had from practitioners on both sides of the profession is that the number of unrepresented litigants is increasing. In a parenting case where you've got an independent children's lawyer, and Legal Aid do a very good job with independent children's lawyers, often the independent children's lawyer will brief because both parties are unrepresented, and it's very, very difficult for the court if there is just no one with a knowledge of the law and of the issues to actually help the case along. Self-represented litigants are less likely to settle because they don't have their own lawyer saying, look, you're never going to get up on that point. You are going badly. You really need to look at a realistic outcome for it. So often they don't because they don't know. And that's why having their own solicitor or their own barrister, if they can afford one, is just so valuable for people.
Can you give me a sense, with your docket this year, how many of those matters would involve unrepresented litigants?
Oh, well, of course, I was running down matters from early on in the year. But looking back over the last few years, whereas it would have been fewer than 10% a few years ago, I think that that percentage would have at least doubled, if not trebled, in recent years. It's quite common for there to be at least one unrepresented party, and it's not at all unusual now, parties on each side to be self-represented. And it is a matter of concern. The Institute of Judicial Administration's looked at it. I've even done a paper on it, and for us, for the court, it's a concern because you've got to do so much more to give these people procedural fairness, to explain to them what's going to happen without running their cases for them, but so they know what it is that they should be doing to present their case to the best of their advantage.